We should be live. Hi, I'm Lauren Cadillac. This is
Jamesha Lambert.
And we are with Cadillac Law. We are live right now, and we are so excited to talk to you about what we've been talking about in the office the whole week.
Mm-hmm.
And we're going to play you clips from the arguments made at trial that the jury is not seeing.
Right.
The jury has cleared out, and so these are like legal arguments. And to me, this is like what lawyering is about.
Mm-hmm.
And so we're going to get into it and do our usual. We told Belinda we'd be doing this, yes, and she said, "Oh, so you're going to do like you did on Wednesday?" And I was like, "That's us. Here we go." Okay, so I'll set the stage. This is Kyle Rittenhouse. He is a defendant being charged with multiple murders, I believe, and he is testifying. Most of the time, you do not put a defendant in a criminal trial on the stand.
For this reason.
For so many reasons,
Mm-hmm.
yes. And, but in this unique situation, they did, so that's really cool, because we rarely get to see that. In civil, we always have to put the defendant on, but in criminal, you usually don't. Okay, so here we go. Someone's just made
Please don't talk about the case.
Here we go. So they made an objection. The jury has to clear out of the courtroom. We always stand for the jury. All right, so now the judge has the jury leaving the courtroom. Now, I learned that this is the most tenured judge in the state, or whatever state they're in. All right, I really liked how the defense matched, and Rittenhouse matched them too.
Right.
And I thought they were doing that maybe the whole trial, but then I watched other days and they didn't match on purpose. So.
Yeah, blue is supposed to be the power color of the court.
Oh, I didn't realize that. Did you know blue's my favorite color?
Mr. Richards?
Your Honor,
Why is my not?
Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions.
Okay, I'm going to stop right there. So defense attorney has made an objection. He is saying, well, first, let me start with a motion in limine.
Right.
So there are motions that we make to the court pre-trial. Any pre-trial motion is a motion in limine. Don't ask me to spell that word. L-I-M-I-N-E or something. Anyhow, motion in limine. So you do those before a jury even walks in the courtroom, and especially in criminal trials, you talk about a lot of stuff, like this piece of evidence, this, and you argue why or why not they should come in.
Mm-hmm.
In this case, the judge had made a ruling that this type of questioning that the prosecution's trying to go down, like his starting, is not allowed.
Right.
And so the defense attorney is saying, hey, when he brought this up, that is cause for a mistrial because he's directly disobeyed this court's order.
Right.
Okay, so that's what's going on here. We're going to hit play again.
I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney.
Okay, so a mistrial with prejudice, that's important too.
Mm-hmm.
What that means is if the judge does give the mistrial and says with prejudice, that's it. They're never going to be able to try any of these facts ever again.
Never again.
It's gone. It's gone forever. If the judge did a mistrial without prejudice, they could retry the facts.
Mm-hmm.
And that's not a double jeopardy issue when there's a mistrial.
Right.
Okay, so here we go.
And he knows better.
Mr. Binger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me.
Oh, hold on. Hold.
Yep.
The court did not leave the door open. The court does not open and shut doors. So we have this thing in law where if something's excluded, like in this case, the judge was not allowing this type of conversation. If the defense had started down that road, then the prosecution can say, Your Honor, they've opened the door. We're going to walk through it, right? Here, the prosecution says the court opened the door, and this is probably why the judge gets so mad. He didn't do anything. He didn't open any door. The defense opened the door. So
it was a misstatement at best.
Yeah, maybe he's nervous. But you're about to learn he's a very experienced trial attorney. He works for the government. He knows these things, or he should. He should know better. Okay, here we go.
Me, not for you.
My understanding of
You should have come and asked for reconsideration.
Okay, so that's exactly what you're supposed to do. If you're the prosecution and you want to kind of go down this line,
even though you know it's already been
excluded.
If
you think the door was opened and you want to go down the line, or even if you don't think the door is open, you would want to reassert your stance on the motion and preserve for appeal. So before you get into that line of questioning, you say, Your Honor, at this time, I'm going to go into a line of questioning the court has made a ruling on, and I would like to make a motion to reconsider.
Right.
Then the judge dismisses the jury and they argue about it and the judge makes the decision. In this case, he didn't do that. He just went into the questions. He just did whatever he wanted.
Can't do that. Yeah.
A lot of male privilege going on here. Okay, so here we go. We're going back. Judge is mad for good reason. Oh, we don't want to.
You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
their motion.
We have not filed any
me.
motions to reconsider in this case.
That was their motion for reconsideration.
By the way, just an aside, this judge has granted a lot of things for the defense.
He did.
So, right. So he's like, well, I granted this motion.
Oh, no, it was for them. Never mind. Just kidding.
Right. Oops.
Yeah.
Okay. And usually in criminal, if a judge has some kind of bias or whatever, it's going to be in favor of the prosecution.
Yeah.
You'll see it, but it's going to be in favor of the dude in the gray suit, not the guys in the blue suit.
You don't tie the state's hands. You usually kind of
tie the defense's hand. Exactly. So this is like really fascinating to watch here. Okay, here we go.
Which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that made it okay for you without any...
Hold on. I think we missed something. I think we missed that part. So he did
hold it open.
Oh.
So the guy knew there's no ruling.
He did leave it open. And
the judge left open, yes. But when a judge leaves an issue open, you don't go into it. You say, hey, I want to talk about the open issue.
You still go ask. But he left it open.
But he did leave it open. So when the guy said the court left it open, and he meant it. He meant it open that way.
Yeah. He left it open.
Okay, here we go.
Advance notice to bring this matter before the jury. I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that.
Okay, so let's talk about that. It's way more than 40 or 50 years, buddy. I think that shit's gone since 1776.
Maybe that's history.
Because that's pretty the Constitution. So in a criminal case, the state cannot talk about a defendant remaining silent. Yeah. We have a right
to remain.
And I suggest anyone that watches this,
please
remain silent. Use that right. Don't say anything. So we have a right to remain silent. And in fact, if Rittenhouse was not going to testify, the prosecution can't bring that up. That's an immediate mistrial.
Yeah, but wait till what comes after.
Okay, here we go. Okay, so the prosecution is bringing up that he used his constitutional rights. So that is a big no-no.
Kind of. We're finna see.
And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion.
First of all, I just want to say this. I don't like his tone.
Who? May I speak?
Yeah.
I mean, you done?
Okay, so if I was the
Are
judge,
you done?
I would be like, "Oh, is what I'm saying delaying you?" I mean, yeah.
I mean, I get it, but you're going on a tangent. You're supposed to keep it together.
I don't think this guy has a good attitude.
Well, we gonna see why.
Okay. Here we go. Okay.
Motion on this exact issue because in my mind, and I argued this, it is identical to what was going on the night of August 25th in the sense that the defendant was using this exact same weapon.
I wish I had a red pointer. This guy with the white goatee and the black suit in the front seat is an expert witness for the defense.
Mm-hmm.
I found that to be interesting.
He was using it in a manner to try and protect property.
No, he wasn't.
There's
Oh, okay. Okay. Well, keep going. It gets worse.
Your Honor, with all due respect,
I'm not going to rehash the motion. Yeah, that's absolutely untrue. No. Your arguments of record, my comments are of record, and why I ruled as I did.
Okay, just so you know, of record means that there's a court reporter and there's an official record. So it also means that can go off to the appeals court if necessary. All right, we'll go back.
Is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time.
Do we pause? No, keep going.
You should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as
I agree with that. Okay.
Defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think.
I love the defense's look.
Oh my God.
That face he makes, we've made that face so many times. Like,
That's
what
me.
are you talking about?
That is
Think of why the defendant would point that gun at
Shaking the
someone.
head.
The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance.
Now, when he got up and he was, you better admonish him, he didn't say nothing. Judge didn't say nothing. Now he talking to explain what is going on, and nobody wants to shut up. But everybody got everything to say.
He said that to the judge, though. It's one
He
thing
can't get his
to
argument
say
on
to
record.
defense, hey, let me finish.
True.
But that is the judge's courtroom.
But how is he going to get on record what he has to say if everybody wants to speak while he's speaking? I get it. It's still a judge.
I get it, and it is his job to
Still a
zealously
judge.
advocate and to get those things on the record. But I feel like if it were me in there,
Right.
I wouldn't be able to approach it with that style.
Even though I tell you to, because
they do it.
they do
They
it.
do it.
They do it.
But
all the
I think I
time.
have to be more courteous. Your Honor, if I could finish. Oh, I do. That's kind of a smart ass
It
thing.
is
I
the
do say
same
that.
thing.
You're right. You're right. We all. That's why we're
Same
lawyers,
thing,
because
yep.
we're jerks. Okay, here we go. We go back. All right.
Chance to make a record if I could, without being interrupted, if that's okay. He has mentioned
What is
that
this
he's
purple thing coming out
acknowledged
of
that
his
he's
shirt?
used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property. It
He
goes.
didn't have the gun with him.
Your Honor.
Okay,
Okay. Exactly.
Yeah.
Yeah.
Judges shouldn't be making arguments. That's the job of the defense. Who is, look at that smile.
Who is literally letting judge do his job
Please.
for him.
Oh, when a judge starts to do my job, I'm like, okay.
Why
chill.
have lawyers when you have a judge?
You don't even need counsel. Okay.
Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
Okay. Okay. So here's the deal. I believe that if Kyle Rittenhouse was black, there would be no difference between saying I could shoot them and then actually shooting them. So the argument the judge is making on behalf of the defendant, I believe the judge is making that argument because the defendant is a white boy.
Absolutely. Because, yes, there is a difference between idle threats.
Sure.
And actually
We
doing
talked about
it.
that on Wednesday. Like, we want to kill our kids all the time. All the time.
In this case, that idle threat turned into actual murder.
15 days later, and in between those 15 days, it was purchasing a gun, purchasing ammo, purchasing body armor. So that wasn't just, damn, I could kill them. It was like, oh, I could kill them, and I will.
Right. Absolutely. And did. Absolutely did.
And they did, yeah. So that really bothers me.
Yes. And the fact that he's making the argument for the defense about the difference between the two. You are not here for that. Now, I get it. They're arguing the motion, so they are supposed to have the banter back and forth. But he's supposed to, at least, in my head, allow the leeway. Okay, you know what? There is a difference, but it actually did happen in this case.
So we've seen judges have an opinion and try to get it out of people.
Right.
They don't do it this way, though. They ask questions.
Absolutely.
Well, what about the fact that blah, blah, blah?
Absolutely.
What about that this person said yada, yada, yada?
Absolutely.
Well, what about this aspect of the law? Not telling it how it is.
Literally trying to understand and see where it's going to go and maybe anticipate where it's going to go wrong at.
But this is not a
But
style.
this is not that.
This isn't a style difference. This is like, especially when I did the appeal.
Right.
I've done an appeal in front of the appeals court. They just ask a ton of questions. And that's what you expect.
And allow you to answer.
And then allow you to, right. Okay. All right. We'll go back. We digress.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. I want.
May I respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay. I believe
that when he spoke that way, he lost.
Yeah, he did.
That was it. That's a wrap. Case closed.
It goes bad.
It's not good. This is, I mean, look at the defense counsel, the ball guy. Look, he's like, oh my God, I can't believe you just said that.
He's feeling for him.
That there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out. So, to your point, Your Honor, you're arguing that this August 10th incident, one aspect of why you don't believe it's relevant is the defendant didn't have the gun with him. This case is about someone who didn't have a weapon, and yet the jury is being told because of those threats.
I need to point out real quick that I went back and watched Monday's victim testimony, and that victim definitely had a gun, and he definitely had it pulled out and was definitely running at Rittenhouse when that victim got shot in the arm that held the gun. So that was for sure self-defense.
Okay. So that was,
But that was after he killed the
number
first guy.
2.
Right. Yes. This is after he killed the first guy.
You killed the
But
first
the prosecution just said this is about someone who didn't have a gun. And while that is partway true, it's also false.
Yeah, but cause and effect. So you literally kill somebody.
Yeah.
And then you expect the people that they're with
to just be cool.
To just
okay.
You know what?
Have fun with that.
No, sir. No.
True.
No.
You're right. That's not realistic.
You asked for every bit of everything that came with the rest of that.
That's why a little white boy from the Birds doesn't belong in that part of town with the AK.
No, he thought he was a little white boy from the burbs, and he was gonna come with the AK-47, and everybody was gonna bow down.
Yeah.
That's not what happened.
No,
that's actually you're more of a target because you tried it.
Okay, let's go back. He tried it.
That means the defendant has to defend himself. So, with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions. I am attempting, with the defendant, to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling, because I thought your ruling was, if the evidence in this case made that more relevant, you would admit it, or at least consider it an admittance. I believe, based on the evidence that we've heard, and more specifically, exactly what the defendant said earlier about admitting pointing a gun at someone who was merely jumping or sitting on a car, that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief...
The door probably was open.
Yeah. He could have very much probably got it.
That's right.
If he would have went and asked.
If he had, before he decided, made those decisions on his own.
Mm-hmm.
And here's the other thing. This guy has practiced in front of this judge before.
Mm-hmm.
This kind of anger coming out of this judge did not come from yesterday.
Mm-hmm.
So obviously this is something that the judge feels this guy has done before.
Yeah. Well, and then, oh boy, lackadaisical over here. I suggest you strongly admonish him, or I'm asking for a mistrial. Judge ain't trying to hear this shit no more. So I'm gonna do that. I'm gonna go ahead and I'm gonna strongly admonish him.
Yeah.
Because I'm not trying to do this again, and I'm
right.
definitely not trying to do it with prejudice.
Right.
Because I'm not trying to have that blowback either.
Yeah.
I get it.
But these are such appealable issues.
Oh, man.
That it's almost like, you know what? All right, call the mistrial. We'll start over.
Mm-hmm. There's so much.
Oh, it's so awful.
Already.
Oh, everywhere. Oh, okay, here we go.
Purpose to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that. But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now, because you're talking about his beliefs. I think that's what they call...
His statements to, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change.
Also, I need to point out, it is so weird to watch this, because when I talk to a judge in Texas, you stand.
Yeah.
You don't ever address the court from your chair unless the court said, sit there and address me.
Mm-hmm.
You get up. So this is weird. I'm like, why is he sitting? Yeah. And then they stand at a podium to ask witness questions. We sit at our tables to ask witness questions. So
Opposite.
it's opposite, which is interesting. Okay, here we go.
Change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior, the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop. And he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission.
That's true.
This is ridiculous.
It is.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity.
Because this energy right here.
Yes.
This energy right here is going to come back around. That's the thing with karma.
But not that. We'll show in another video that the same issue comes up the next day, and defense is doing what prosecution had done, and judge doesn't seem to care.
Yeah.
It's interesting, yeah. So we're not getting the same energy.
It's real cute right now, though.
Indeed.
Evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the
Don't
defense testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these.
Own mouth.
You're right. But it was before that testimony. And that judge said, don't get brazen with me. It's funny because usually we're not really, like the prosecution, we're like, yeah, burn. But right now we're like, whoa, why aren't they getting a fair trial? No, the roles have really
reversed.
Yeah, it's hard to really want the government to win, but you do.
These types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity.
So the judge is saying
he sees no
propensity evidence is like the idea that I guess if someone like a serial killer had tortured cats when they were a teenager or something, you would put on evidence that they were an animal torturer, that they have a propensity to do these kind of things or hurt living beings. And so the judge is saying he doesn't want propensity evidence in this case.
Which is fucking,
you're right.
Nuts. Being that he had the propensity because he did it.
Because he obviously, he was carrying an AK on his chest. You know what I've never done?
Right.
Gone out in public with an AK strapped to my chest.
Had my friend buy it.
And then get body armor.
Get body armor.
Never done that.
Drive to a location.
Totally out of town.
Walk around
and flash my gun.
Point it at people.
Yeah, I've never done any of that.
15 days before, say that I would do it. And then, no propensity evidence.
No propensity.
No, we're going to take that out. We're going to tie your hands with that. Okay, great. Wonderful.
Yeah. But if he looked more like you, we would hear about how his dad was in jail and his uncle and his grandpa. So his family has a propensity.
Oh yes. We're just gonna get all of that in there.
No justice.
Between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these.
So he doesn't have it. When did he actually buy the AR-15?
I don't know. I was thinking that he bought it after he made that comment, but now it sounds like maybe he bought it before he made the comment. But he didn't buy it. He had a friend buy it because he wasn't 18, so he's not legally allowed to own a firearm.
So, because we're just going to...
Let alone an assault rifle.
That part. So, he says, I'm going to do it because he already has it, clearly.
Right. Yeah.
He names it.
Yeah, I wish I could take my baby.
But because he doesn't have it with him right then.
When he said that. Yeah. Then it doesn't show a propensity. Right. Yeah, it's totally irrelevant.
Because he could have said, I wish I could take my gun. I wish I could take my firearm. Or
right. Yeah.
He named it by name.
Right.
Okay.
Yeah.
But not propensity.
No propensity. No. He's
to be shoplifters. And the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to.
He needs to.
It's murder.
It is murder, but he's a judge, and so he shouldn't use
that term. Okay.
Inflammatory language.
So
right. He does need to say incidents.
But the fact that you can identify the fact that the incidents in this case with propensity.
I didn't make these.
Shoot at somebody, or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time.
Okay.
So I
need to time the fuck out, because last time I looked into this topic, every single murder just takes matters of time.
No. What? Each one of these incidents, which is what, 3? 4?
Yeah. Are we calling victims incidents now?
Yeah.
Oh, okay, yeah. Then there's 4.
And then
2 are dead. No, 3. 2 are dead. For sure, 2 are dead.
For sure, 2 are dead.
One had his bicep blown off.
And each one took matters.
It's just matters of seconds, Jamesha. That's why we wouldn't be able to show a propensity, because,
Oh, so is that him trying to say 15 days prior in matters of seconds are totally...
Yeah. So it's like if OJ had said, I'm going to go slice up Nicole and that dude she's with 15 days before, and then he went and sliced them up, but it only took a few seconds.
That would be totally... He didn't have the propensity
right.
Then.
Exactly. No propensity. Exactly. There we go. Yep. There we go.
I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest.
This is not a prior act. And wouldn't you think that the AR-15 is the symbol?
Girl.
Okay. Oh, okay. Let's go.
It's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions.
Oh my God. Oh my God. Oh my God.
Okay, so I'm trying to,
Under this theory, no propensity evidence could ever come in. Ever. Unless somehow the murder took minutes instead of seconds.
Because now we're taking away premeditated. If I said I'm going to kill my husband 15 days ago.
And then I kill him.
Me telling you that I was going to kill him 15 days ago should not matter, correct? So that
wasn't
means you
the
can't
same
take
judge just
premeditated.
mad about this guy trying to change 50-year-old law?
Oh, yeah. Oh, girl, we ain't even.
Didn't we in this live session we're doing right now just hear him? This is the point where we're going to stop and take a moment to let people know judges are human.
Yeah.
And we hear that kind of crazy shit every day.
Yeah.
Every day. And then our clients are like, why
What
didn't you
happened?
know? And I'm like, because I don't make the judge's breakfast.
Yeah.
so I have no idea what kind of mood they're in.
Right.
Or if they're going to change case law or written law from hundreds of years ago.
Or if he plays golf with the person on the other side of the table, or if that person donated to their campaign, or, you know, whatever may be going on in their social outside of the bench life, we don't control that.
Maybe their wife's divorcing them and she has bangs.
Absolutely. And so that reminds you.
Yeah, no way to know, right? Like, people think judges are infallible because they're judges. And I'm not going to dispute they are highly educated. Most judges are very hardworking, very intelligent.
Absolutely.
But no human is infallible. And the whole point of the law is that there's two sides, right? That means that each of us have a different point of view, and the judge is supposed to be someone who sees both point of view and then makes a decision accordingly, right? And y'all don't know all the time this happens. They just, you know, they're in a mood or whatever. I don't know this judge. I've never seen him before. I saw this on TV. But my guess is he's kind of moody.
Right. But that's what's disheartening for us too, because we hear this, we see this, but the people who are going to decide whether this man is innocent or guilty are not getting to see the totality of the situation.
And they're hearing this judge make objections and doing all this stuff in front of them.
Right.
And so they're going, this infallible judge, this almighty
who's sitting on the throne.
They are not privy to this.
Exactly.
And if they were, they really wouldn't know what was going on anyhow.
Right.
So it can be frustrating, as we know, to be in this side of things where, you know, our clients are like, well, why didn't you do it? It's like, well, the code says this and the judge chose that. I have no control over those things. None whatsoever.
But that's why we have the balance in saying, okay, let's take it to appeal because this, and this was wrong.
Exactly.
And we let someone over them, thank God, go decide whether or not that judge got it wrong.
And we then have a Supreme Court that can do the same. Right, because we understand, or well, we don't. The founding fathers understood that humans are human.
Right.
But this kind of stuff happens every day in courtrooms.
Absolutely.
And you should not get mad at your lawyer. It's not their fault.
Right. Well, not all of them.
Well, yeah. Don't get mad at me. Don't get mad at us. It wasn't our fault. All right, we'll go back.
Whether premeditated murder or whether self-defense, that's for the jury to decide. But I don't see the similarity.
How are they going to decide? How? If we have no propensity evidence, how can we decide whether it was premeditated or self-defense?
Right.
Nobody was around him.
To your point, he took away the whole, if you're taking away the ability to prove premeditated. Gone. Well, hopefully they did lesser included charges.
Well, one day they
Casey Anthony, that was that lady. Remember that lady that killed her kid? I couldn't remember her name the other day. They didn't do the lesser included, and that's why she's walking free.
That's why George Zimmerman got off too.
Florida is weird with that. Why don't they do that?
All or nothing.
Dumb. All right, here we go. Back to the scene, and we are like 40 minutes. We could do this all day, literally. We're gonna take a break in a little bit though, because I gotta eat.
Yeah, I'm hungry.
Me too. Okay, we'll go back.
I said it couldn't come in, and it isn't coming in. No matter what you think.
Oh!
Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is
backtrack.
This is you know what? I get it. Not trying to do this again. Definitely not trying to have that blowback. So, sir, because you see him look at him, I'm admonishing him, like you asked.
Right.
But we ain't finna do this again, so I'm gonna just
Backtrack a little here. Here we go.
Well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as...
Okay, here's the other thing. These government employees, prosecutors, break government rules all the time. So the fact that he said he's astonished that the prosecutor did that, to me, that's a joke. If you're astonished, that means you've been blind and deaf every day of your tenure on that bench because you have seen the state do that every day. I mean, how many times do you hear about the state, withholding evidence?
Mm-hmm. All the time.
How are you?
He's on TV. He is being...
Well, he does this thing where he gets really upset and then he rememers he's on TV and he tries to calm down. And then he goes in and then he's like, oh shit, I'm on TV. Oh shit, I'm on TV.
I see it.
This case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
Okay, they're going to adjourn there. We're going to adjourn there. This was just a brief. There's so much more for us to explore.
So much.
But I hope you've enjoyed hanging out with us. This is like literally all we do. We just yell at the TV.
This is our crazy.
Well, we do a lot of good work.
Right. And because of situations like this, we are able to kind of go back and forth about how the fairness, while at the same time understanding that
the system.
It's the system.
And it's great to watch other lawyers work.
Absolutely.
Because we can learn from them. I mean, I've learned I've taken cross-examinations from lawyers I've heard. Oh, that's good. Ooh. We borrow each other's work all the time. So, thanks for joining us.
Bye.
We'll see you next time.